Call us to order, and we'll begin with the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Anybody's going to present testimony. If you're going to present testimony, you go ahead and stay standing, and I'll swear everybody who's going to present testimony in today. Do you swear from the testimony you give the truth, the whole truth, and nothing but the truth?
I do.
Thank you. For the respondents in the room, my name is Drew Smith. I'm the Code Enforcement Special Magistrate for the city. I am not an employee of the city. I am a practicing lawyer in local government law. My role in these proceedings is to be an independent fact finder, so we will proceed today by hearing each case. Are we going to go in the order of the agenda? In the order of the agenda. The city will begin each case by presenting their evidence and testimony regarding the facts of the case. When they're done, you'll have an opportunity to ask any questions of the code enforcement officer you may have, and to present to me any testimony and evidence you would like me to consider in reaching my final determination. At the end of each case today, I will issue a verbal ruling that will be followed in the mail by a written order that will include everything that I include in that verbal ruling. And with that, clerk, you may call the first case.
Case number 2022-392, Edward Torres Garcia, owner, location of violation 2311 Biddle Way, St. Cloud, Florida.
Good afternoon, Melissa Howes, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: a copy of the courtesy notice of violation sent by regular mail, a copy of the notice of violation sent by regular mail, a copy of the notice of violation sent by certified mail, copy of the notice of violation sent by regular mail posted on the property and City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted on the property and City Hall, a copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code section in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $198.16, and the respondent is not here.
Thank you.
On March 8, 2022, I received a complaint that the fence permit for this property had expired prior to scheduling a final inspection with the building department. I checked the permit number B20-4906, and it had expired on November 19, 2021. That same day, March 8th, I sent out a courtesy notice of violation to the owner of the property, giving him 10 working days to comply by renewing the permit. On March 21st, I checked the permit. It was still expired. I issued a notice of violation for an additional 10 working days to comply. On August the 6th, I checked the permit and compliance had not been met. I then issued a notice of violation by certified mail, which was later returned as unclaimed. On April 22nd, I had not had any contact with the owner and the permit was still expired. I sent out a notice of violation by regular mail, posted the property and City Hall, did an affidavit of posting, and took one photo of the posting. On May 16th, the permit was still in non-compliance. On May 19th, I sent out a statement of violation and notice of hearing by certified mail, posted the property and City Hall, did an affidavit of posting, and took 3 photos. On June 6, while preparing my case for the special magistrate meeting, I checked the permit and it had been renewed and is now in compliance. A final inspection was also completed and the permit has been closed out. It is the city's recommendation that the respondent be found in violation of allowing a permit to expire prior to scheduling a final inspection. The city would also request that the cost incurred in bringing this case before the special magistrate in the amount of $198.16 be paid within 7 days of the magistrate's written order. And that concludes my presentation.
When was the permit renewed?
It was renewed it was a couple of days prior, so paid to renew the permit on 5/19, the same day I posted the property. But I did not check it until June 6th when I was preparing my case. A little history on this is there's a dispute between neighbors, so you can figure out who called a complaint in.
What's your date for compliance in your notice of violation?
On my statement of violation, you mean?
What was the date? No, what was the date for compliance that you notified, that you included in your notice of violation?
May 9th.
Which notice is that in?
It's under your case summary.
No, I'm looking in the notice of violations themselves. Which notice of violation?
Oh, it doesn't have a date. It'll just say 10 working days.
That's what I'm looking for.
Okay.
I see it in the statement of violation. I'm looking for it in the notice of violation. So that would have been your April 22nd notice?
Yeah, the last notice would have been, yes, April, when I posted the property. It would have been 10 working days from that date, which would have been April 22nd. Yes, sir.
I'm looking for that language in the notice.
The 10 working days you're asking for?
Where was the respondent told 10 working days?
It would be, if you go to the second paragraph under where it says if worked described, and you go to the last sentence, it says it shall be renewed at half the original price within 10 working days from receipt of this notice.
That's what I was looking for. Thank you.
I'm sorry. Okay.
No, it's okay. No, I just, it was in the block language. That's why I kept on skipping over it.
Okay.
That was my question. Okay, there's nobody here on this case?
No, sir.
Okay. And based on the evidence testimony received, I'll find in favor of the city, find that the respondent was in violation for allowing the fence permit to expire prior to calling a final inspection, find that the respondent cured that violation by renewing the permit, and that the property is now in compliance also because the permit has been finalized out. Find the respondent did not cure the violation within the time allowed in the notice of violation, and for that reason, order the respondent to pay the administrative costs incurred by the city in prosecuting this case in the amount of $198.16, which amount will be due within 7 days from the date of my written order.
Thank you, sir.
Case number 2022-584, Jose Hernandez and Nancy Medina, owners JAA Illuminations and More LLC, location of violation 5080 Silver Thistle Lane, St. Cloud, Florida.
Melissa Howes again, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: a copy of the email sent to the business owner, copy of the notice of violation sent by regular mail, copy of the notice of violation sent by certified mail, copy of the notice of violation sent by regular mail posted on the property and City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted on the property and City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $206.16, and the respondent is not here. On April 13th, 2022, after receiving an internal report from the Planning Department for all non-renewal business tax receipts and certificate of use licenses for businesses licensed within the city that did not renew, this particular business was JAA Illumination and More LLC. I reached out by email on renewing the licenses and also reached out by telephone. I spoke to the owner, Jose Hernandez, and advised him that he needed to get the licenses renewed within 5 working days. On April 22nd, I checked the licensing records, and the business tax receipt and certificate of use had not been renewed. I checked the state corporation website, and the business was still showing active at this location. I sent out a notice of violation by regular mail to the owners of record, which is also the owner of the business, giving them 5 working days to comply. On May 5th, they were still not renewed, so I sent out a notice of violation to the business and the owners. On May 19th, the certified mailing card was returned but marked COVID-19, and the licenses had not been renewed. I then sent out a notice of violation by regular mail, posted the property in City Hall, did an affidavit of posting, and took 1 photo of the posting. After returning to the office on May 19th, I received a call from Wanda Medina, one of the owners of the property, wanting to know why the sign was in her front yard. I explained that the business licenses for her husband's business had not been renewed, and I had already spoken to Jose about getting the licenses renewed with no success. I had sent out several notices and compliance was not met. I explained to her where she needed to go to get the violation resolved, and she said she would take care of it. On June 1st, 2022, the property was still in non-compliance. I checked Sunbiz again, and the business was still showing active at this location. On June 2nd, I sent out a statement of violation and notice of hearing by certified mail, posted the property in City Hall, did an affidavit of posting, and took 1 photo. On June 13th, and again today, I checked the licensing records, and the business tax receipt and certificate of use are still in the delinquent status and in violation. I also checked Sunbiz, which is still showing the business as active at this location. It is the city's recommendation that the respondent be found in violation of having not renewing the business tax receipt and certificate of use business licenses while still operating the business JAA Illumination and More LLC by the time specified at this location. The city would also like to give the respondent until June 30th, 2022 to correct the violations or pay a fine in the amount of $100 a day until compliance is met. The city would also request that the cost incurred in bringing this case before the magistrate in the amount of $206.16 be paid within 7 days of the written order by the special magistrate. And that concludes my presentation.
In talking to the respondents, neither of them said that they've stopped operating business, did they?
Neither one.
Okay. Did either of them confirm that they are still operating business from the property?
No, but when I went to go post the property, there was a commercial vehicle there. There was no riding on it, but there was all kinds of equipment on the,
Okay. And nobody's here on this case?
no, sir.
And based on the evidence testimony presented, I'll find in favor of the city, find that the respondents are in violation for not renewing the business tax receipt and certificate of use licenses while continuing to operate the business on the subject property. Order the respondents to cure the violation by June 30th, 2022. If not brought in compliance by that date, a fine in the amount of $100 a day shall run until compliance is met. Also order the respondent to pay the administrative costs incurred by the city in the amount of $206.16, which amount will be due within 7 days of the date of my written order.
Thank you, sir.
Case number 2022-685, Sharon Rife, owner, location of violation 3446 Cypress Point Circle, St. Cloud, Florida.
Melissa Howells. At this time, I would like to enter into evidence the following items: a copy of the notice of violation sent by regular mail, a copy of the notice of violation sent by certified mail, posted on the property and City Hall, copy of the statement of violation and notice of hearing sent by certified mail, posted on the property and City Hall, a copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $199.16, and the respondent is not here.
Thank you.
On May 2nd, 2022, during routine patrol, I observed high grass and weeds at this location. I sent out a notice of violation by regular mail to the owner of record. On May the 3rd, I took 3 photographs.
What am I seeing in these photographs?
Well, I know, I mean, I should zoom on some of them, but if you look back by the fence, you can see the high weeds. It's pretty much underneath the tree and where it's not been weed eated because the tree shades the area, so it doesn't really, it grows a little faster there.
So that was really my question. I see along the fence, that's easy to see, but up here in the foreground of the photo, is all of that underneath that tree overgrown?
Yes, it's all weeds, yeah. And I think I zoomed in a little closer, further into the presentation. On May 16th, a reinspection was performed and the violation was not corrected. On May 17th, I sent out a notice of violation by certified mail, posted the property in City Hall, did an affidavit of posting, and I took 5 photographs. I tried to go from different angles so you could see. That was a little bit more of a close up.
So it looks like the property's being mowed, it's just those areas that need to have a weed eater taken to them.
It's not being mowed. I'll explain it to you
Okay.
here in a second. On May 31st, a reinspection was performed and the violation was not corrected. 4 more photos were taken. On June 1st, I sent out a statement of violation and notice of hearing by certified mail, posted the property on City Hall, did an affidavit of posting, and took 1 photo. On June 10th, I was in the area and seen that the property was mowed and was in compliance. I took 2 photographs, which kind of shows you how much of a big difference it is. So here's what happened on June 10th. I received a phone call from the owner's daughter stating that her mother just passed away. And she's trying to get her affairs in order. I explained to her that since the grass was cut and now into compliance, that I would only be asking for a finding and the cost incurred, and she said that she understood. It is the city's recommendation that the respondent be found in violation of having high grass and weeds at this location and not corrected by the time specified. The city would also request the costs incurred in bringing this case before the magistrate in the amount of $199.16 to be paid, I would say, within 60 days with her having to do the mother's affairs. I just took this case to the magistrate a couple of months ago on the vehicles in the driveway. I don't know if I have any. You see the red car there? So we are running daily fines on that. Just FYI, I did explain to her the procedure once she gets the car gone to call me immediately to stop the fines from running, and then she could contact Claudia on possible reduction.
Okay.
Okay?
And there's nobody here on this case?
No, sir.
Okay. Based on the evidence testimony received, I'll find in favor of the city. Find that the respondent was in violation for allowing grass and high weeds to grow on the property in excess of 8 inches. Find that the respondent cured the violation, but that cure was made after the time set in the notice of violation for cure. Will order the respondent to pay the administrative costs incurred by the city in the amount of $199.16, which amount will be due within 60 days from the date of my written order.
Thank you, sir. And you're up.
Unfinished business, respondent requests, case number 2021-2658, Investment One USA, Inc., owner, location of violation, 722 Illinois Avenue, St. Cloud, Florida.
Good afternoon, Jack Morganson for the city. These last 4 items on the agenda are, in essence, requests for reductions under the $50,000 accrual fine amounts. The first 2 items, Investment One USA, 722 Illinois, and Asset May Enterprises, 810 8th Street, you should have in your file, Your Honor, two fully executed requests for reduction. The first of which, investment one, location of 722 Illinois, the amount of accrued fine, $4,650 from some unpermitted work which occurred back, I think the hearing was held in March of this year. Total accrued fine was $4,650. The recommended proposal, which was agreed upon by the respondent, is to pay essentially half that amount, $2,325 within 30 days of your magistrate's order, if agreeable to you. The second of which...
Staying with the investment one case?
Sure.
Has that violation been cured?
Yes.
Are they now in compliance?
Correct.
They are now in
Yes,
compliance.
correct.
I'll go ahead and enter the order on that one, then before you move on to the next one, I will
Yes, sir.
approve of the settlement within the same terms as included in the agreement between the city manager and the respondent.
Yes, sir. Thank you.
So that one's approved.
And without moving too quickly, but just moving ahead to the property at 810 8th Street, again, the respondent has agreed to the city manager's proposal the accrued fines were $900, and the parties have agreed to a settlement amount of $450 to be paid within 30 days of your order, should you agree to this reduction and payment on that
And
property.
again, is the property in compliance now?
Yes, I believe, yes, it is.
And I will enter an order approving of that settlement and along the same terms as included in the written agreement between the city and the respondent.
Thank you, sir.
Reductions under 50,000, case number 2020-2239, Quality Plus Realty LLC owner, location violation, 706 New York Avenue, St. Cloud, Florida.
Your Honor, Jack Morrison for the city. I believe the respondent is here and wants to be heard on this particular
Okay.
matter. This matter, there is not an agreement that's been reached between the city and the respondent. Respondent wants to be heard, and I think submitted a written request for your consideration. Just a little bit of history on this case. It deals with 706 New York Avenue. It dealt with some work which was done prior to obtaining a permit. The matter was heard back last year in April of 2021, and the respondent was ordered to come into compliance by the end of May 30th of 2021. Compliance was ultimately confirmed earlier this year, March 23rd of 2022, and so there was an accrued fine amount of $29,400, and when you build in the administrative costs, the total amount owing was $29,645.80, which has accrued. The city, I believe, interacted with the respondent, but agreement couldn't be reached, and so the city went ahead and through the acting city manager, Deputy City Manager Miller, submitted their recommendation of a reduction down to $4655.80 if paid within 30 days. Respondent is here. There's a written offer from Mr. Escobar, which you should have before you as well, in which he is proposing a much lesser amount, and I know he wants to be heard. So I'll step
Okay.
aside and let you all talk.
Okay.
Thank you.
Respondent?
Good afternoon. I have a timeline here that I could submit.
Sure. You can show it to council before I receive it, if you wouldn't mind showing it to city's attorney. He's still responding.
Okay.
Go ahead.
So I requested a reduction because I feel that I gave this, or the city had adequate time to get me approved before the May 30th date. I submitted plans, as you see, 321, and those same plans were the ones that kept getting denied and then approved by zoning. So zoning held it up for quite a while prior to it going into the hands of the building department. I feel that if zoning would have approved it in its time, everything else would have been approved with due time.
So I see the back and forth in your timeline. Is it your position today that all of these comments that you were receiving on the plans were unfounded?
Yes. So, yes.
But you ultimately corrected them.
No, I didn't correct anything. The only thing that I had to correct was the garage, because it was a 20, and that was after the fact. That was for building. I mean, that was for zoning. But everything else, like according to the city land development code 3, all that, they ended up finding me that was grandfathered in.
Okay, so between 423, you made a resubmittal. Between 423
321 was the original
and
submit.
1215, no, but I'm looking at 423 of 2021 and 1215 of 2021. What did you change in your application materials?
I'm sorry, from 423 to when?
To when you resubmitted the final one that was approved, 12/15/2021. What did
So
you
from
change?
423, when I resubmitted the plans, I ended up having to request for a pre-application. They gave me a date of 6/17.
Okay.
So that already passed the 5/30 date. And then I was disapproved by zoning again, same plans. I'm submitting the same plans, not doing any changes yet. We had a second hearing here, submitted minor changes. The minor changes were interior stuff we had to do with building, not zoning at this point. And during this point, I asked zoning, they kept denying me. I kept asking if there was any other comments other than this one comment that they kept posting. And they said they couldn't give me that information yet. The last, until the 29th today, he told me that I had to move the driveway 10 feet back from the alley. So I had to give the 10 feet of the alley plus a 20-foot for the garage entrance, or for the driveway. So in that case, all I had to do was set the garage 10 foot back. And that was disapproved on 11/29, and I submitted by 12/15 those corrections.
Okay, and my initial order was on 421, so it was before the 423 resubmittal.
Say that again, I'm sorry?
My order was 421 of 21,
Your order for,
requiring cure of the violation
oh,
regarding
the first order?
Mhm.
Okay, yeah, I didn't have that written down.
So that was 421, and then you resubmitted,
Yeah, 423.
and you had, so what happens between,
So, okay, I just remember now. So 421, I had it still as a, no, it was a duplex. It was
that's okay,
still-
I'm just
no, it
trying
was
to
a
understand
duplex.
your timeline.
Got you. And then
These aren't meant to be hard
423, I
questions.
resubmitted as a duplex, and then, but then I requested the pre-application meeting. And then they pushed it back to 6/17. Oh, that's the date that they gave me. That was the first date that they have for everybody to be available.
Okay, well, here's the box I'm in. I can approve a settlement between the parties. I can't compel the city to accept a settlement. So I cannot tell you today, you only have to pay $250.
Okay?
I do see a long timeline here, so I think it might be worth expanding the conversation and seeing if there's any more room the city might move. Not my call to make.
I would only, not to interrupt the flow, I understand that Officer Miller does have some information the magistrate might want to take into account that speaks to some of the timing that the
Okay.
respondent is
And again,
speaking to.
I don't see that I
Right.
have any authority to do anything today,
Right.
because without an agreement between the parties,
Right.
I can approve a settlement agreement. I cannot compel one side or the other to accept a settlement agreement.
Understood.
So I don't know that that's helpful to me, because ultimately again, I approve the settlements, but I don't sign off on I don't agree to the settlements. So that might be information that's more appropriate for the city manager's consideration in considering the facts.
Sure.
So I hear what you're saying, and I do see where you were making efforts. I see a lot of times, though, where efforts being made, but, you know, things don't move as fast as anybody wants them to. I do think, and why I'm encouraging maybe there's another conversation that can happen at City Hall, is maybe there are some periods here. He makes an application 4/23, he's got to make compliance date, and he has a pre-app meeting in June. You know, there's some days there that a fine was running that, you know, he was waiting for a pre-app meeting, and I'm sensitive to that. But we are where we are, and I only have the authority I have, which is to approve settlement agreements, not to make them. Okay?
So you're gonna give a suggestion, or you just?
I've said everything I'm going to say. I've suggested that maybe there's more conversations to be had, but I am not the
Gotcha.
city. I do not represent the city. I cannot advise the city.
So I got a dilemma with another property. So my lien is on all my properties right now. I have right now a pending loan on one of my properties, and I can't move forward with that loan until at least I get like some kind of a release on that one property. So I have to, you know, before, I'm not saying we can't come up with a solution today, but if I could get that released or.
I do not have the authority to settle the case for the city. I do not represent the city.
Gotcha. Okay. That's it.
Thank you.
Thank you.
There's his exhibit, and there's your file back.
Okay.
Case number 2021-2076, Russell and Tabitha Alexander, owner, location of violation, 725 Maryland Avenue, St. Cloud, Florida.
Yes, sir, Your Honor. Jack Morganson for the city. This is a matter in which an agreement has been reached, and you should have a written agreement between the Deputy City Manager Miller and the respondent. This is a case that was heard in November of last year. Accrued fines reached $16,500. Administrative costs $261.90 for a total of $16,761.90. Owed, the parties have agreed that a settlement amount of $2,736.90 to be paid within 30 days of the magistrate's order to resolve the outstanding matter. It dealt with abandoned vehicles, grass, exterior, et cetera, that had not been maintained.
And is the property in compliance?
And the
did you say?
property is in compliance, yes. All of these that were presented to you for these reductions are in compliance, yes, sir.
And sir, do you wish to say anything? You don't have to. Anything you'd like to say? Okay.
You wish to speak? No? Okay.
And based on the presentation by the city attorney, I will approve the settled amount in accordance with the terms of the agreement signed by the respondent and the city manager.
New business, July meeting canceled. Next scheduled meeting, August 17, 2022.
Okay, anything else from city? No, sir. All right, then we are adjourned.
I do have a question. Do you have a moment?